I'm Scott Lachlan. This is the Data Chronicles, and here are your data points. On today's episode, we are going to discuss the future of data regulation in Europe, in particular, the Digital Services Act, or the DSA. And when I say future, I mean now for some companies and the imminent future for many others, starting early in 2024. Privacy and cybersecurity professionals are well accustomed to regulation. This is not new, but these regulations are different. They are novel in design and comprehensive in scope and really go beyond the uses and disclosures of and protections of data. Instead, these laws go directly to how digital platforms can operate going forward. It is a big, big deal. To discuss these developments and the future of this space, I have invited my partner, Antonia Galam-Carezada, in our Hamburg office. Antonia is one of our team members who is leading our task force and team focused on digital regulation in Europe. Antonia, welcome to the podcast. So Antonia, maybe you can start with giving us an overview about what is happening in the digital regulatory space in Europe. I think many of our listeners hear so many things that are happening from the DSA to the DMA. Can you just give us a perspective on what the future looks like in Europe on digital regulation?
Yeah, and I mean, perspective is something we all are very much hoping for. It's not that easy because it seems we're waking up to new developments every day in Europe. It started a while ago with regulations such as the Omnibus Directive, which address the relationship between digital services and their consumer users, so consumer protection focused. Then we had the P2B regulation, the platform to business regulation, which as its name suggests, deals with the relationship between digital services and their commercial users, their traders. Now we have the DSA, which is a horizontal regime that covers every type of intermediary that does business in Europe. So any service that has to do with the processing of third-party content, third-party information, and the Digital Markets Act, which you refer to, which is the antitrust sidekick to the DSA. Then we have, beside these very broad regimes, we have very specific ones, such as the CSA regulation, which addresses CSAM content. The terrorist content regulation is being finalized at the moment. Then, of course, we have all the privacy-specific regulations like the Cyber Resilience Data Act. We have the AI Act that everyone is talking about that is also being sped along in the legislative process at the moment, which also takes a very broad and risk-based approach to any type of AI systems. So in short, it is very easy to lose sight of what is happening, and it's a very fast-paced environment. And sometimes we have the unfortunate impression that the legislator is also losing sight a little bit, because many of these new laws overlap and not always to the best effect. There's a lot of ambiguity and unclarity about which one takes precedence in which specific situation, how do they complement each other, which one of them do I have to comply with, especially if I'm a non-European based business. And so the questions are many, and the need to get on top of compliance preparations is very strong at the moment.
Yeah, I mean, that's a really great and interesting point, because as I hear what you're describing, there is a lot of things happening with respect to digital regulation in Europe. In fact, maybe that space is going to change forever in the way that it's been regulated or going to be regulated going forward. And I think I heard what you were describing is that there are some of these laws that are being proposed and going to be implemented that are going to have sweeping application. And then there are some that are going to be much more pinpointed to specific oriented problems. And so you mentioned the AI Act was going to have sweeping implications for any AI. I'm sure the cyber regulations are going to do the same thing for everybody. But in particular, the DSA, or the Digital Services Act, is going to be one of those laws. And so maybe I'd be very interested in your summary. What is the DSA and why is that important for companies with a digital presence in Europe to know about?
Sure. So the common denominator of the DSA, the Digital Services Act, is that it applies to intermediary businesses only. So any type of digital service that includes the processing and perhaps also the publication of third-party content. This can be either just mere conduit and caching services, or it can be hosting services. Or on the next level, it could be so-called online platforms where the hosted content is also made publicly accessible. And of course, the typical use cases for that are social media, marketplaces, app stores, booking sites. So any type of platform that operates heavily with third-party content. And then at the very top of the ladder, there are the so-called very large online platforms, which are currently a designated 19 very large big tech platforms, which have been identified by the European Commission as surpassing a level of 45 million average European users on a monthly average, and have a really extensive set of obligations attached to this designation. And some of them are at the same time also so-called gatekeepers under the Digital Markets Act, which I mentioned before, which looks at the antitrust elements of these supersized tech companies. And so given its very broad application to all intermediaries, it is really quite critical under the DSA to know exactly which type of intermediary your business falls into. And while that may sound pretty straightforward, believe me, we've done a lot of scoping for a lot of different services. And there's so many innovative digital businesses nowadays that it becomes increasingly tricky to really say, oh, this is an online platform, this is just hosting, this is not hosting at all, it's just caching. And sometimes, of course, platforms combine various of these elements. So it is complex, and the fact that the DSA is a horizontal regulation that applies to any type of intermediary, regardless of which specific industry sector the company is active in, makes it all the more complex, because of course we have to work with general obligations that have very different impact to the different types of businesses.
So, Antonio, can you help me understand what that intermediary concept looks like? Because I think there may be some organizations who would clearly fall within that. You know, you mentioned social media or kind of different types of e-commerce platforms, but there are many companies who don't really see themselves as a platform, but are also integrating with third-party content and third-party services in order to enable their services. How broad is that concept? So in other words, does it mean that I have to be able to collect data or provide services that would be then further distributed to consumers? Or does it just mean that I get data and I don't even have to distribute it, but I'm still an intermediary as a result of it?
Yeah, so it doesn't have to be consumer facing necessarily. You could also be a B2B business and still fall under the DSA. So the DSA is agnostic in that respect. But it does require processing of third-party information. In other words, users providing the service with their content. So, for example, a file sharing site would be a typical example. And depending on how this file sharing site is set up, it could be a mere host. For example, if users can store their files but can only share them through individual links with individual users. Or it could be fleshed out as a fully fledged online platform, as in the YouTube example. The file sharing is done on a public interface which anyone can access and where anyone can see the content that is shared there.
So I have a lot of specific questions, but maybe I'll reserve those for future conversation. I guess it would be very helpful for me to understand, and perhaps our audience as they're looking to understand how and when this is going to apply, is what is driving the need for the DSA, and why are the legislatures in Europe looking to adopt this at this moment in time?
Yeah, that's a really good question. And the clear driver for the DSA is the aim to eliminate to the best extent possible any kind of illegal content and any kind of content that violates the terms of use and policies of an online service. And that correlates with this requirement of intermediating third-party content. So it goes hand in hand with the liability concept also. So historically, already under the e-commerce directive that has been in place in Europe since the millennium, an intermediary will only be liable for this third-party content, which is provided by users and merely hosted by the intermediary, if it is made aware of an illegal piece of content in a sufficiently substantiated way, and then does not act swiftly enough to remove or disable the illegal piece of content that has been flagged to it. So this is the typical takedown process, which you also are familiar with under the DMCA, of course, in the IP context. And the DSA is now extending this to any kind of illegal content that is under EU harmonized law or under some national law of a European member state. And at the same time, the content moderation that goes along with it also captures content that may be legal, but is prohibited under the specific terms of service of the intermediary in question. So you have the liability regime of the e-commerce directive that is being continued under the DSA and is being fleshed out by very detailed new rules about content moderation, the communication between the intermediary and the users, both the reporting user and the user whose content is concerned by the notice, appeal mechanisms, collaboration with authorities in case an authority flags a piece of illegal content. So keeping the internet free from illegal and violative content is at the core of the DSA.
So I'm interested in that because you mentioned the DMCA, which is a concept that I think many in the US are familiar with, where there's infringing content that's posted on a particular site and then there's a takedown process. What are the other big categories of unlawful content? That concept, I think, in some ways is a little unusual in the way the United States works, given we emphasis on free speech. Are we talking about the content and the messages, ideology behind the messages themselves or the videos or whatever content that's being posted? And then second part of that is, whose job is it to determine whether this content is quote unquote unlawful? Because that can be a tricky thing.
Yeah, it is tricky. And you really hit a nerve with that question, because that, of course, is a significant difference between the DMCA and the European model, because to the extent that I'm familiar with the DMCA, the intermediary or the platform in question who receives a DMCA notice just passes it along to the user whose content it concerns and asks the two users to sort it out among themselves, and will only step in with a decision of its own if the two can't reach an agreement. And in contrast, the DSA is really asking platforms to step up to the level of private courts, if you will, because they will really have to determine if something is lawful or is not lawful according to any applicable law in the European Union. And of course, that's a huge obligation, and the service operators sit between a rock and a hard place, because they have the obligation vis-a-vis their uploading users to keep their content live if it is legal, and not take any premature takedown decisions. And at the same time, of course, they can become liable themselves directly for any piece of illegal content which they don't act on swiftly enough after they've received a notice. So they have these two obligations on both ends and sit in the middle with liability attached to their decision. And it's really difficult. So what many intermediaries are doing at the moment is to take an elegant approach that kind of bypasses this obligation to assess something under every single law. I mean, come on, would you know what the law is in Lithuania if you're an American platform operator and your content moderation team has to process a notice coming from a Lithuanian user and alleging some specific illegality under local law? That would be pretty much impossible. So what everyone is doing is they are ramping up their terms of service and their content policies. They are ramping up their playbooks that they give to their content moderators and putting the emphasis more on their own terms of service and their own policies to take the takedown decisions in the context of those, and also to provide the required statement of reasons along the lines of their own policies, with which they are, of course, much more familiar than any national law. But on the face of it, by the letter of it, the DSA actually does ask service operators to assess the legality of a piece of content according to whichever national law is invoked in the takedown notice.
Fascinating. We've seen similar scenarios play out for things under like the GDPR in order to allow for individuals to exercise the rights of deletion or right to be forgotten, or the similar ones where there has to be a stand up of a process internally to take in those requests and to be able to evaluate those requests as to whether they are lawful and whether there are any particular exceptions apply, and doing that kind of balancing. But it seems, and I think that experience reinforces, that when you're asking private companies to play the role of the arbiter of these things, or almost even the jury and the judge for being able to determine this, is that what you're seeing, is that companies are going to be asked to play this role? And then if so, are they standing up specific functions that are going to try to handle these types of requests or be able to conduct this type of moderation, and then do a process where you're trying to understand whether something has to be taken down? I mean, what does that look like internally?
Sure. So the answer is yes and yes. I mean, companies are indeed going to be held accountable for making these judgment calls and making these legal assessments. But they are being helped also by the requirement under the DSA that they only have to act on notices which are so well substantiated and are pointing so clearly at an illegal piece of content that it is made as easy as possible for the platform to take that decision. In other words, the platform or the other type of intermediary won't have to go fact-finding or researching case law. It is up to the notice reporter to provide all the information the platform needs to make the decision, but then it will have to make that decision and be held liable if the decision turns out to be wrong. And so, of course, all the big players in that space have their own dedicated content moderation teams, which can run into the hundreds. And at the moment, we already have the first transparency reports published by all the very large online platforms, where if you're interested to take a peek how it looks in reality, you can check out how TikTok, how Facebook, the Google Play Store, Amazon, Alibaba, AliExpress, and others are dealing with their content moderation. And this goes down to the level of them having to say how many of their moderators speak a specific language, etc. So it really drills into the details, especially for the very large online platforms. And if you are operating a business that centers around third-party content and you're active in Europe, you really cannot do this without dedicated content moderators. I mean, the obligation has already existed under the e-commerce directive, but there's so much political weight being pushed behind the DSA and its enforcement, and it's coming into effect. And the European Commission is already sending out stern letters left, right, and center to some of the very large online platforms, which the Commission feels may not be sufficiently compliant for individual elements of the DSA. There's so much scrutiny and so much importance attached to this new law that it really will be enforced quite consistently.
So a couple of things that you said I wanted to follow up on, maybe that last point where you're indicating that regulators at this moment are sending around either letters or having different types of communications, or even in the media saying that company X, Y, and Z is not yet set up.
Actually, X did receive the first of such letters.
So maybe
formerly
then
known as Twitter.
Maybe the question then is, well, to what extent is the DSA currently in effect? And if it's not yet in effect, when will it go into effect? And why are companies, before the law is effective, getting these types of communications?
Yeah, very good point. So 19 companies have been designated by the European Commission as so-called very large online platforms. And I mentioned TikTok already, Facebook, also Instagram, Snapchat, Amazon, Booking.com, Twitter, or now X, Wikimedia, and a few others. For these companies, the DSA has been in effect since the end of August already. And so they already had to publish their first transparency reports, for example. And everyone is now looking, of course, very closely at how did they change their terms of service? How did they change their content moderation information pages, their notice intake channels? What did they put into their transparency reports? So all the other platforms are now looking for inspiration on how to do it themselves, because everyone is pretty much scratching their heads. And I know from clients that there are even regular catch-up calls between various platforms where everyone is trying to figure out together how to best approach unclear language in the DSA and how best to approach some smart risk decision-making that will have to be made in the light of certain unclarities in the text. And the big date for everyone else will be the 17th of February 24. So this is just 2.5 months away now. And then it will be fully effective from that time onwards.
Yeah. So what you're saying then is that the DSA is currently in effect for 19 or so designated operators of large platforms, but then early 2024, a couple of months from now, it will go into more broad effect for others who also fall inside of the scope. Got it. And is there a phase timing around what the obligations look like? Or does all of the obligations kick in February?
All of them kick in at that point, with a very few exceptions. So for marketplace businesses and app stores, so basically B2C platforms, certain KYBC obligations, so vetting the existing traders, can take another year. So, for example, if a marketplace wants to onboard a new trader, they will have to do KYBC for that new trader immediately before allowing them to use the platform. But for the existing traders, they have a year longer to do that. Another example is the transparency reports, which for everyone but the very large online platforms will just be due after a year of the DSA having been in effect, so in February 25. But all the ongoing obligations on content moderation and on the marking of advertising, for example, advertising transparency, avoiding dark patterns, certain rules on recommender systems, protection of minors, transparency and clarity of the terms and conditions, and everything else kicks in all at the same time in February.
I think one question that I think many audience members will be asking themselves is, okay, you mentioned, Antonia, that this was going to apply to companies who have significant operations in Europe. Now, as folks who are involved in determining how the GDPR is going to apply, it's very important to try to understand if there's establishments and to what extent that there is targeting of EU audiences and really kind of all of the other parameters of Article 3 under the GDPR. If I'm a company outside of the EU, in the United States, elsewhere, how am I determining to what extent these laws are going to apply? Does it matter at all if I have to target the audience, or is there another test for extraterritoriality application of the DSA?
Yeah, so you can already take home as a baseline rule that the applicability will be interpreted quite generously. But then there's a subset of determining factors. So if you have an establishment in Europe, you're captured. And if you do not have an establishment, then the question is indeed that of targeting a significant proportion of European users, of course, without there being any hard number guidance, unfortunately, on what this proportion might look like. But if your service is accessible in Europe, if you provide things like prices in euro, language options, other localization features, and other forms of service like support service under local phone numbers, for instance, then your service will also be captured. Typically, in today's global day and age, pretty much everyone will be captured, I expect.
So you started by saying that this law would be interpreted generously. You do not mean generously to businesses. You mean generously to
to the regulator,
to regulators.
To an all-encompassing applicability. Yeah.
Yes, but some of the things that you were describing in terms of that test, I think are familiar with, because there's similar concepts under Article 3 of the GDPR and even under the prior regime before the GDPR. But there really needs to be some level of nexus to Europe. It doesn't mean that you have a US-based business, for example, who someone decides to put up a user review and that they're based in Germany, that's automatically going to result in the application of the DSA. It's going to look at a number of other factors relating to how that company operates, including to what extent they have that nexus within Germany or any other member state.
Yeah, exactly. So maybe a good example might be a website which, similar to Amazon, has various country-specific sub-sites for its service. And so, example, you have a .com domain, and you also have maybe a .eu domain or a .de domain, .fr domain for your German and your French content. And then the question is, given that you already operate your service on certain European URLs and domain names, would your .com domain also fall within the ambit of the DSA? Probably not, but maybe yes, if you're a marketplace and people can also order something from your .com domain if it's not available on the German or the French dedicated website. So all of these are questions where the answer is really clearly not straightforward, and where it's important to do a solid analysis of existing services so that you have all the information you need for scoping under the DSA, both in terms of your geographical coverage and in terms of the type of intermediary and the corresponding obligations that the DSA will impose on you. That's a really important, critical first step in the whole process of looking at DSA compliance.
So just going back maybe to something that you said, but I think it's important just to emphasize, can you help me understand what are the companies that would want to be concerned about? Like, so in other words, if I offer a platform, I'm going to be subject. If I'm allowing user reviews, I'm going to be subject. Are those tests, those key kind of like, if this, then you are going to be subject? Any of those kind of jump out to you that you want to make sure the audience here knows?
Yeah. So As a very simple baseline, every user content which you host makes you subject to the DSA if it has the sufficient connection to Europe, that is. And then where you also make that content publicly accessible on your interface, then it merits looking more deeply into the extent to which you do so. For example, you mentioned user reviews. If I have a retail business with my own online shop for my own brand, and then there's also user reviews on that, of course, I'm hosting those user reviews, which my users have uploaded, but that doesn't make me into an online platform. That can fall under the so-called minor and ancillary exception, where I'm only subject to the hosting requirements under the DSA, which are more basic, but I can get away with not having to comply with the full set of online platform obligations. On the other hand, if my entire business is about user reviews and all that I publish on my platform is user reviews, then that's a different story. Then, of course, that's my key service. And then I will be considered an online platform for all my user review content. So hosting, whichever content you host, you have to comply with the DSA for. Online platform, it depends on the scale of posted content, which you then also publish, and how important that content is to your core service.
I think one question that I think a lot of folks have on this is just maybe not even out what the regulation of the law requires, but instead of practically how are organizations approaching this, including who best within an organization and their legal team would be carrying this type of effort forward, because there's not typically a digital regulation lawyer that most companies have internally, maybe outside of some of the very large platforms. It's a similar issue that we're seeing with respect to artificial intelligence. Who is going to be the one to lead artificial intelligence? Is that privacy and cybersecurity? Is that IP?
Yeah. Who picked the short straw on having to do the DSA list?
So, the DSA, what are you seeing in terms of specific functions within inside of an organization say, yes, we are going to own the responsibility for implementing the type of policies and the types of processes and the types of governance that you were describing?
Yeah. So to be honest, we're seeing everything, because it also really strongly depends on the focus of the business in question and the size of it, of course. So we are seeing everything from dedicated DSA task forces where one person is in the lead and works with all the teams on advertising, privacy, etc., relationships with traders, and so on. We're working with clients where this is spearheaded by their IP legal team. We are working with clients where privacy is in the lead. There's no solution and no approach which I haven't seen, I think. And that also makes it tricky, because sometimes it takes a while until someone feels responsible for this topic and says, oh, we have to do something about this. And sometimes it may even be that teams are working on different solutions for their respective silos. So it's really important also within the organization to address this across teams, across legal teams, across business teams, and talk with the tech teams also to really get a holistic approach and make sure that you've got every aspect of your business covered.
One of the mechanisms you were describing earlier, which I'm thinking about as you're describing this, is the terms of use and the terms of service that sit within inside of an organization. At least in my experience, many organizations have difficulty assigning an owner of the terms of use and the terms of service, in part because that really cuts across so many different functional areas that there is not an obvious owner. So, for example, it could address things relating to product, right? So it could be a product lawyer who is going to be responsible for it. It could be address issues relating to litigation and what types of arbitration provisions and what types of class action waivers you have in place. It could address issues relating to IP and kind of what people can do and cannot do with information that exists on that site. And importantly, for many of my clients, it ends up affecting privacy and cybersecurity as well, including what data may be able to be used, how data can be uploaded, what are the rules surrounding implementation of safeguards, including viruses and so on. And it results in some lack of cohesive ownership over a document that really spans multiple disciplines. I mentioned AI earlier. AI is experiencing that same issue right now. Is it cutting across multiple disciplines? And what I hear you're describing is the DSA is going to be another example where it's going to cut across multiple disciplines and there's not an obvious owner. And so organizations are both flexible in assigning owners, but also it's an area where there's a significant, I don't know, call it an uplift, a significant area where existing teams are going to have to add skill sets to cut across all of those disciplines and all of those subject matter requirements.
Yeah, that's absolutely spot on. And that's what we're seeing and have been seeing for the last 3 years that we've been working on getting clients ready for this. That some are more prepared than others and some are more collaborative than others. And that it's really critical to, if there's no obvious first choice for an owner for the DSA compliance lift, that you assign one internally and have very clear structures of the other teams contributing the relevant information for their specific sectors of the business, so that you can really look at everything holistically, as in the example of the terms and conditions which you mentioned, which is of course also just another aspect where the DSA requires review processes and updates.
Yeah. What do you think, Antonia, about what the first enforcement looks like? So you mentioned organizations already receiving letters or communications from their regulators that they don't think that those early entities who are subject to the law are meeting their obligations. What does enforcement look like under this regime? How do you see that playing out in practice?
Yeah, that's a really important question that probably has multiple answers. So for the big tech companies, which you mentioned, the very large online platforms that are already subject to the DSA, their regulator is directly the European Commission. And then for everyone else, we have national regulators, the so-called digital services coordinators, which are newly formed organizations, newly formed authorities within each member state. And the member states are currently in the process of naming these or newly creating them. Some of them have already done it, others are still in the process of doing so. And so the level of scrutiny and enforcement will very much depend on which member state is your member state for your competent digital services coordinator, which will depend on where you have an establishment, if you're a non-European entity, and if you do not have any main establishment in Europe, which country you designate for a legal representative, which you will then have to appoint. And so, of course, if you are based in Estonia for your digital services coordinator and your enforcement, your reality will likely look very different than if you sit in France or in Germany, where traditionally there's quite a proactive and aggressive enforcement attitude for all things digital. And then if you sit in Dublin or in the Netherlands, it could also again look quite different. It will depend on the typical approach the different countries take towards either working collaboratively with businesses to find business pragmatic solutions to challenges and to objections, or if there's a top-heavy ordering of businesses to comply with certain requests, and there's not a lot of dialogue happening. So also the choice of your legal representative and your country of jurisdiction within Europe will, to a significant extent, determine how your future as being regulated under the DSA will look like as a non-European business.
Is there a similar process that we have under the GDPR where organizations can designate their lead supervisory authority? And, we folks who are familiar with the GDPR often will say, like, to what extent can we work with one authority versus other authorities in Europe having taken more aggressive positions or different positions than your supervisory authority? Do you sense that the same thing is going to be playing out here, right? In other words, you have one set of rules. Obviously, reasonable minds can look at those rules and apply them differently. And you may have regulators in Germany who are thinking about them differently than in France, than the Netherlands, and then in Spain. How are those differences going to be reconciled for organizations who are planning for this?
Yeah, for sure. That's a very real consideration. Exactly like you say it, reasonable minds will very much be able to find different answers to many aspects of the DSA, because it is quite poorly drafted in some parts and leaves quite a lot of question marks open. And also, of course, manpower and budget and so on will also play a significant role in how enforcement will play out in each country. And to avoid that a single platform business could be exposed to requests from various different regulators from different countries, the DSA assigns one primary DSC, Digital Services Coordinator, to each business. And which one is the one responsible for your business will depend on either where your main establishment is, if you have one in Europe, or if you don't, you can actually go pick and choose and go forum shopping and appoint a legal representative in a member state of your choice. And then that legal representative, which can be a natural person or can be an entity, can be held liable and accountable directly towards the DSC of that country. And if any other DSC has an objection with that business, they first should go through the DSC of establishment, and so that everything is routed through the country of establishment for that specific intermediary.
Well, I'm sure there's going to be a lot of lessons learned over the course of how this is being rolled out. But maybe my last question, Antonia, before we wrap, is just thinking about this moment in time, where organizations, some of which have probably a clear idea what their responsibilities look like under the DSA because they are already covered by that law. There are probably many others who maybe know about it a little bit or maybe have learned about it, but as one of my clients likes to describe it, put it in their denial pile. So my question for you is, suppose you are a lawyer who's in-house and you have an IP litigation background, but let's say you are the designated lead of
the designated
regulation.
survivor.
What are you and your senior executives comes to you and say, Antonia, I've heard about this DSA. I read about it in the Wall Street Journal. What is it that we need to do? Where do we need to start? And maybe that would be the question I would ask us to finish on.
Sure. A very good place to start would be first to do the scoping, which I've mentioned a few times. So really take a position internally of whether your business is a hosting provider that just has to comply with the hosting set of obligations, or whether you're even an online platform, or if you only do caching and conduit. And once that is clear, then the best place would be to start with the outward facing content. So your terms of service, your notice intake channel, because that, of course, is the place where anyone can go looking and see if you appear to be applying or maybe not. And I don't just mean authorities who can go looking, but also, of course, your competitors or consumer protection authorities and agencies who may take up any perceived non-compliance issue on behalf of consumers and send you a cease and desist letter, or even take you to court if they perceive this non-compliance to be significant and worthwhile fighting over in court. So get your ship ready on the outside first, if you're pressed for time and pressed for budget, and then work inwards and look to get your internal workflows ready so that you can provide a responsive content moderation process, as well as the accompanying appeals processes that you have to provide, like internal complaints mechanisms and working with outside out-of-court dispute settlement bodies. And then maybe look at the further details, such as avoiding dark patterns and having your recommender systems identified and giving users certain choices for recommender systems. So all these more granular details of compliance would come at a later stage. So get the terms ready, get the policies ready, inform your users about their rights under the DSA and how you work with them to ensure compliance, and then take it from there.
Great tidbits there, Antonia. Thank you so much for joining the podcast. I'm going to ask you to come back from time to time and talk about the developments in the space, because it sounds like there is a lot to know and a lot to do as this law starts to take a more broad effect on organizations and starts to mature. With that, thank you everybody for joining. I'm Scott Lachlan. This is the Data Chronicles, and those were your data points.